Okay, good afternoon. Just give it a few more seconds whilst we wait for a few more participants. A few more. Okay, we're approaching a quorum. Okay, I'll get underway now. Good afternoon and welcome everyone. Thank you for joining us. First up, I noticed that some of the attendees today are from New Zealand or operate in the retail sector. So whilst this weekly Q&A series will be drawing upon our Australian experiences with office tenants, the Australian legislation, the Australian Code of Conduct, the principles will remain relevant to New Zealand and all real estate sectors. Nevertheless, those of you that operate in the retail sector, I'd encourage you to look into our weekly retail Q&A series, which takes place every Wednesday at 1 o'clock Sydney time. Further details can be found on our website, lpc.com.au. So, my name is Michael Raymond. I'm the head of our industrial division, and I'll be acting as your host today. My role is threefold. First, to introduce the weekly Q&A webinar series, in which we will be focusing on the impacts on leases and the workplace post-COVID-19. Second, to introduce the speakers for this week and the questions they'll be answering. And third and finally, to manage the Q&A session at the end of our presentation. So today our speakers will be Julian Carrath, one of our directors specialising in the office sector, who will be speaking to the first question being, how will lease clauses adapt post-COVID-19? Now this is a wide-ranging topic, so today will be part one of that question. Julian will hand over to Rebecca Pelling, our Managing Director of Project Services, who will speak to the second question being, how many people can my workplace accommodate? Again, this question has wide-ranging ramifications, so we'll continue into the following week. Next slide, please, Niels. The format for the series has been drawn from frequently asked questions we've been receiving in relation to post-COVID-19 lease and workplace readiness. It is based on our successful weekly Q&A webinars we've been running for 7 or 8 weeks now for our retail tenants. Each week we will have 2 expert speakers. They'll speak to one question on post-COVID-19 impacts on leases and one question on the workplaces to the impacts to the workplace. There will be a 20-minute presentation and 10 minutes at the end for questions. So if you have any questions on the way through, please feel free to use the Q&A function at the bottom of your screen, and I'll get through as many of those as I can at the end of the presentations. So without any further ado, I'll now hand over to Julian, who will speak to question 1, how will lease clauses adapt post-COVID-19? Julian, next slide, please.
Thanks, Michael. So how do we get leases ready post? Can everybody hear me now? So how do we get leases ready post-COVID? There's a couple of areas that Lpc Cresa has been assisting tenants navigate in navigating COVID. The first is rent relief, which relates to the immediate response and impact of COVID. We've also been assisting in relation to lease restructures and renewals and getting leases ready for post-COVID, which is the topic of today. And then also portfolio optimization where tenants occupy multiple sites. So today's question, how will lease clauses adapt post-COVID-19? The answer is actually, if we can go to the next slide, Michael, the answer is actually relatively simple. It's all about transferring risk over to the landlord, and that usually equals greater flexibility. It's nothing new in terms of the transfer of risk. We deal with it in every lease negotiation that we undertake. So the question here will be, what parts of a future pandemic are we able to pass over and have the landlord carry that level of risk? So week 1, which is today, we're going to be looking at the pandemic clause and what that looks like. In future weeks, we'll be looking at a backdated COVID-19 relief, in particular where we haven't been able to obtain relief under the Code of Conduct, mostly in relation to 50+ million dollar companies. Also be looking at contraction and termination rights during a lease, but also ones that are triggered on the back of a pandemic. rent reviews will become relevant, and there's obviously different views from the landlord and the tenant. Building performance, and especially the services that allow us to access our premises. And then also, are there any tenants that we want to prohibit from being in the building? If we go to the next slide, please. So the pandemic clause, the focus will really be, in relation to this clause, will be on mitigating future risk. And the principle here is about utility. So the inability to occupy the premises or the space will be the principle of this clause. Now, we've reviewed leases on the back of what's happened with COVID. And in Australia, there's very few clauses in our leases, and New Zealand, there's very few clauses that actually deal with such a pandemic. Overseas, they do have force majeure clauses, which we do see here in Australia and New Zealand, but they usually relate more to agreements for lease as opposed to during the lease term. And a force majeure clause deals with an extraordinary event or circumstance beyond a tenant or landlord's control that prevents one or both of them from fulfilling the lease obligations. And the consequence is a potential termination right from the affected party. And this has been challenged in relation to COVID, mainly because the period of time of the impact is at this point has been relatively low. So the ability to terminate has been pushed back on quite substantially. So if we focus on utility as being the underlying principle and the inability to occupy the space, and we look at what lease clauses do we currently have that somewhat relate to this. And the most obvious one is the destruction clause under a lease, which allows us, where a building is destroyed or partially destroyed, allows a reduction in rent until such times as the landlord rebuilds or reinstates that the affected premises. And if they don't, then the lease terminates. So that is probably the closest clause that is in a lease currently. Another good example is obviously the Commercial Code of Conduct. The issue with, and the regulations, the issue with this is that the overlay relates to revenue loss, and understandably, landlords, when we talk to them about a pandemic clause, as we have over the last couple of weeks, there's a pushback in relation to why should a landlord bear, just on the back of a downturn, a reduction in rent. So the principle again comes back to utility. The best example is probably the Christchurch earthquake, and on the back of that is the Auckland District Law Society created a standard lease from 2012, and that lease under clause 27.5 provides that if an emergency stops a tenant accessing their rented space, then a fair proportion of the rent and outgoing shall cease to be payable for the period commencing on the date when the tenant became unable to gain access to the premises to fully conduct the tenant's business from the premises until the inability ceases. So this is probably the closest clause to what we've got to a pandemic clause. The issue is, and why it was relevant in Christchurch, is because some buildings were still standing and the authorities had actually closed them off, and therefore the tenants couldn't access those spaces. Now, in relation to now, the COVID impact has been that some utility has still been used. So we need to, whether it's 5 or 10%, we have still been able to access some form of our premises. So we need to ensure that it's not, that it has regard to being able to partially access the premises. The other piece is the accessibility on the back of restrictions to the building services. So the lifting issues in particular is a focus now that we're all starting to head back to work. And what does that mean to actually being able to access the space? Even though we may have social distancing plans in place for our premises, if we can't get the people there, that is an issue. And we spoke to a premium building yesterday in relation to that particular issue. And for premium lifts, they spoke about being able to move 180 people per hour up and down the building. So if we assume that there was a 3-hour peak period, that's 540 odd people. And that building pre-COVID was able to occupy 2,500 people. So you can see the issue around the accessibility through buildings services such as lifts. The second part of the pandemic clause is the rent reduction. And we've spoken during COVID about waivers and deferrals. This clause would very much be focused around a waiver, not a deferral. And then C, the affected period. As per the Christchurch lease or the Auckland District Law Society lease, it's about the affected period as opposed to a set period within a lease. So the day that we become affected to the day that the period, to the day that we can get back to the premises. So that's a very quick snapshot of what the pandemic clause will focus on. I'll now hand over to Rebecca to talk about workplace readiness. Thank you.
Thank you, Julian. The underlying question for this series is how to reoccupy the workplace. Sorry, I'll just start my video. Hopefully you can see me now. The underlying question for this series is how to reoccupy the workplace living with COVID-19. The work that Lpc Cresa does for tenants in response to this challenge has 3 foci. They are ensuring that people are ready for that challenge, ensuring that the place is ready, and that the protocols are there to support the above 2. So the question today is, how many people can my workplace accommodate? And I'll show you the solution that we've been adopting and employing to assist our clients. Can we go to the next slide, Michael? Thank you. So today the focus is to be able to answer this question is the development of a workplace reoccupancy plan, or as I like to call it, a plan on a page. This plan has regard to restated business objectives, the people constraints, the workplace constraints, the building constraints, and the commuting constraints. However, for the purposes of today's session, due to time restrictions, I won't specifically address those constraints today. I'll be very focused on answering the question, but we will be addressing these in subsequent sessions that form part of this webinar. I would like to refer you to a site on our website, which is resources.lpc.com.au/knowledge, where we have a number of the templates and forms that I'll refer to that are from the Safe Work Australia. So they're essential in preparing any plan. Next page, please, Michael. So what you see in front of you is a sea of red. So we like to start the analysis with doing a risk assessment. And there is a risk assessment tool prepared by Safe Work Australia, but I like to put it on a plan. So for the premises that are presented here, the reason that it's a sea of red, which is a high risk, is that it's an agile workplace and it meets 2 criteria. Most of the areas are shared and have many common touch points, and it's difficult to guarantee the 1.5 metre separation. So this is before putting in place any protocols or place modifications or people behaviour. The areas that are shown in amber are actually offices. And so they are shown in amber because they're assigned to one person. However, due to the placement of visitor furniture, it may not necessarily be able to maintain the 1.5 metre separation. And there isn't anything that is low risk in green because the safest place to be is at home. If we go to the next slide, please, Michael. So the aim of undertaking a workplace readiness plan is to try and shift the areas from red and amber lower down the risk scale. So in this instance, and what I like to do with all analysis is start by analysing each of the work points. This is a 6 workstation pod arrangement, and in the first instance with scenario 1, technically you could reoccupy that and it would be at 100%, but the risk level is high and you'd be very heavily reliant upon people and protocols to maintain separation and distancing. If we move down and reduce density to a 50% occupation, and in this instance we're checkerboarding, we are again reducing risk, but the question to the client is that a level of comfort that you're happy with? And then scenario 3 is showing a 30% occupancy, where with these circles at a radius of 1.5 meters, you can see there is even less chance when occupying the work point to be able to easily maintain the physical distancing. So once we've analysed the scenarios and had the discussion with the client around what they're comfortable, if we go to the next slide. What we do, and I'm not expecting people to be able to necessarily read the plan, but this is the outcome of translating the work point analysis. And so we apply this tool to all of the work points, be they offices, kitchens, breakout spaces. And by creating a plan on a page and this utilisation and occupation plan, that will give us the answer to how many people can be accommodated on a floor. In this instance, the client was working to a 50% occupation, and we have a team A and a team B. And so it's reduced from 146 to 73 people. This doesn't, as I've mentioned before, take into consideration any of the constraints associated with people, the building, or public transport. Now, it should be noted that using this methodology can apply to any sector or industry, whether it's a retail outlet, an office, or a industrial shed. So next week's question, this is such a big topic, will also continue to address density. Thank you, Michael.
All right, thank you, Rebecca. Now, just a few questions we have, and perhaps the first one I will direct to Julian if he's available.
Sure.
I'd hope he is. So Julian, what would be the implications on a pandemic clause if the government initiated another code of conduct with regulations? Would it supersede this clause?
Look, that's a great question, actually. The answer is the legislation, government legislation, does supersede it. And I guess the risk with that is where we've seen the code of conduct be mandated for companies below 50 million, and it being good faith discussions above 50 million. The same principles obviously apply, but the ability to force an outcome is far more likely on the mandated component. So what we would want to do, and the reason for having such a clause, is to ensure that it is a forced outcome. So we would need to ensure that there's appropriate wording to say that the clause represents good faith discussions, so that principle is already set within a lease that the mandated response can then have regard to.
Okay, thanks, Julian. Another one, perhaps to you, Rebecca. What are some easy, inexpensive solutions to prepare our workplace?
Okay, good question. So, look, most of our clients to date have not wanted to spend any money because it's an interim solution, and how long we have to live with this is unknown. So we've had to be quite innovative, or even just apply really simple principles. So for example, the touch point on a door handle represents high risk, especially if it's a door handle to meeting rooms. And the cost to necessarily automate opening or closing can be expensive. So within the protocols that would support the return to workplace, there can be protocols such as literally chocking the door open. The next step up is obviously applying hands-free devices. Another simple tool is using signage. There's lots of signage on the Safe Work Australia website that you can download just to reinforce ideas.
Thanks, Rebecca. And perhaps another one for you, a slightly novel question, but we have 2 monitors at each of our workstations. Are these good enough as protection?
I have actually been asked that in the past, and if it were my workplace, I wouldn't rely upon 2 monitor screens. I don't know that the research around how far coughs or, you know, the projection. I don't know that 2 screens that partially obscure your neighbour would be effective in that event. So I wouldn't rely upon using my screens as a barrier or form of protection.
Okay, thanks. Look, that's about it for questions, unless there's any more that are coming through in a short while. No, perhaps not. We like to try and keep this nice and punchy, so and leave as much time for questions, but perhaps we'll leave that for next week. So that brings to a close this session. Please join us the same time next week for our next webinar in this series. Next week, as the slide suggests, our experts will be tackling part 2 of how will lease clauses adapt post-COVID-19, and we will continue with how many people can my workplace accommodate. If you could just flick on to the next slide, please. In the meantime, if you have any questions, please don't hesitate to contact one of us. Our details there are on the screen. Also, I'd like to take the opportunity to remind those of you that are in the retail sector that we have a weekly Q&A series that runs on Wednesdays. Further details, our website again is lpc.com.au. And finally, for all of those that attended today's webinar, you will receive an email shortly with a link to the recording of this webinar. Please feel free to share that with your colleagues or whoever you think may be interested. So once again, thank you for joining us. Have a good afternoon, and we hope you can join us again next week. Thanks very much, everyone.